The situation occurs and they think it's no big deal, so they go to the hearing and now they're compromised, and there's the defendant or the respondent is like, well, what I should have called earlier, is there anything I can do? How can I appeal this order of protection?
Yeah, and it's funny you say that, because we probably get a couple calls each week, that somebody in that exact situation thought it wasn't a big deal, or they say, here, I get this one a lot. These were BS allegations. I didn't think I needed a lawyer. Truth is on my side, which is probably all the more reason to get a lawyer, right? But I get that one a lot. We get probably 3-4 calls a week. Folks that walked out of the courtroom and say that, I didn't think I needed a lawyer, and they went to the hearing and the order of protection was granted for a period of usually 1 year or more, and they're calling to try to undo this now. And I always tell them, I said, unfortunately, this process got a lot more complicated and expensive, because now, like you just mentioned, we're talking about appeals. There's really only two things. We can do a motion to set that aside, which generally is not going to be, in most cases, it's not going to be effective. You're asking the judge to undo their ruling. I mean, it's like a parent that grounds a child, and then, your child comes and says, hey, can you vacate your decision?
It's like telling a judge, oh, you were wrong.
Yeah, and them saying, yep, you were right, and I'm overturning it. So, but that is a possibility, and we filed them in some cases when the facts, certain unique facts, circumstances. But in appeal, an appeal goes to a higher court. So you start at the trial court. Let's say we're in St. Louis County. Now, if you have to appeal that, you're appealing to the Missouri Court of Appeals, Eastern District. It's typically a 9-month process, give or take. Like I said, it becomes a lot more expensive, a lot more time consuming, and a lot more complex to try to undo what the judge already ruled on.